Welcome back to the Michigan Business Beat, brought to you on the Michigan Business Network. Chris Holman here. And we're coming to you from our studios at the Capital Region International Airport. And spend a little time right now with Alex Rusek. He is a shareholder with Foster Swift attorneys, headquartered kind of in Lansing, but all over the state these days. I think there are 5 different offices that you guys have. Alex, welcome to the show. It's good to see you.
Oh, and thank you for having me again.
Oh, it's great. Listen, you guys bring us up to date on all kinds of things that are legal, and today is no different. Can you explain what happened in the case United States versus Hepner, kind of in layman's terms for us?
Absolutely, Chris. This is actually a criminal case out of the Southern District of New York. So, even though with that background, this is going to be applicable to a lot of people because it's one of our first decisions regarding artificial intelligence and the confidentiality that may be associated with using those systems. So, Mr. Hepner, he was charged with white collar crimes in New York. And in his defense, he decided to use the AI program Claude, and he put in some information that was relevant to his defense. What ended up happening was that Mr. Hebner actually printed out that information from Claude, and when the FBI raided his home, they took that information. Now, Mr. Hebner argued this is attorney stuff. This is legal. It should be privileged. It's confidential. And in one of our first rulings, really addressing this issue, the New York court held that one, there is no attorney-client privilege with an AI system, and then also that the work product doctrine that would generally protect what our attorneys do for us also didn't apply because Mr. Hepner was not instructed by his attorney to put this information into the world. So now we have this one decision, and it's going to have implications across the country and across the world, I believe.
Yeah, and of course, these are decisions that have the implications you're talking about that really impact business. How does this change how business leaders should kind of think of using AI strategy for problem solving, internal discussions, etc.?
Absolutely, Chris. We are hoping that our business leaders have already been taking these kinds of issues into account, and Hepner should just be putting really the exclamation point on there. But what we have to be cognizant of is confidentiality when we're using AI. If you've ever had a chance to read through the dozens, if not hundreds of pages of the terms of use for these different artificial intelligence systems, many of them say that they can retain your data. They can use your data to train their artificial intelligence systems, and your own data could end up being put out from that system to people that you don't want it going to. We also have a risk of those companies selling our data. So, especially when we start thinking about trade secrets, cutting edge strategy, we have to be exceptionally careful that we're not putting our hard work and all that confidential information out into the world.
Well, this is very timely because we use Claude and GPT. What risk could that create with confidentiality and legal protections, such as privilege, right?
Absolutely. So if we are using a public system, it's out there, we don't have any kind of specific agreements in place, then it's likely that the user who puts information to that system is going to waive any kind of confidentiality that they may have enjoyed previously. So we think about things such as trade secrets, customer lists, those all could potentially be exposed. We also think on the legal side of what privileges may be waived. If you were to put in, say, an email from your attorney because you want more information about what he or she has explained to you, then you can easily waive the attorney-client privilege by putting that information into this third-party system without taking the appropriate steps to protect the entity.
So, practical steps for organizations to take kind of right now from a standpoint of safety with AI.
Absolutely. So at the bottom, we have to be aware of the pitfalls that come with AI. We know that we're going to get false results sometimes. We know that these AI systems hallucinate. And we've just talked about these big issues of confidentiality and privilege. So, at bottom, we need to be aware of these issues. We need to train our staff. We have to have policies in place that staff can rely on when using AI systems. This should be an ongoing training because of how quickly these systems are changing and developing. We also want entities to verify and approve any AI system that's going to be used by their employees. We want to have, again, the appropriate AI use policy in place, and especially for entities that are dealing with issues such as protected health information or other kinds of private client information, then we want to make sure that we have the appropriate business service agreements, business associate agreements, master service agreements in place to take care of some of those privilege and confidentiality issues that we've been seeing.
Well, it's incredible to get the services. You have to agree with a like 15-page document that you really need an attorney to read to begin with. Hey, Alexander Rusek, thanks so much for joining us, shareholder at Foster Swift Attorneys. We appreciate what you guys do there to help us keep on top of things for business.
Thank you again for having me, and be safe out there when using AI.
You're absolutely right. You're watching the Michigan Business Beat on the Michigan Business Network.